the senator from South Carolina.
Thank you. I'd ask unanimous consent to terminate the quorum call.
Without objection.
Thank you, Madam President. This morning, I'm going to announce my decision on Judge Jackson's nomination to the Supreme Court. I will oppose her and I will vote no. My decision is based upon her record of judicial activism, flawed sentencing methodology regarding child pornography cases, and a belief Judge Jackson will not be deterred by the plain meaning of the law when it comes to liberal causes. I find Judge Jackson to be a person of exceptionally good character, respected by our peers, and someone who has worked hard to achieve her current position. However, her record is overwhelming in its lack of a steady judicial philosophy and a tendency to achieve outcomes in spite of what the law requires or common sense would dictate. After a thorough review of Judge Jackson's record and information gained at the hearing from an evasive witness, I now know why Judge Jackson was the favorite of the radical left, and I will vote no. In the area of child pornography, there's been an explosion in this country of child pornography on the internet. In 2021, groups that follow sexual abuse of children on the internet reported 29.3 million reports of individuals accessing information regarding child pornography on the internet, and it has gone from 100,000 in 2003 to 29.3 million in 2021. There's estimated that there's 85 million images and videos and other files involving sexually exploited children on the internet. Now, why is this important? This is the venue of choice for the child pornographer. It is not the mail. As you can see, the internet is where these people go. In a matter of minutes, they can download hundreds, if not thousands, of images and videos of the most disgusting abuse of children. And my goal is to deter that, not discount it. Judge Jackson's sentencing methodology, in my view, misses the mark. I don't doubt that personally she's offended by the behavior that we're all talking about, but as a judge, she has an opportunity to deter the behavior of going on the internet and downloading images of exploited children. Every time she has that opportunity, she refuses to exercise it. Now, why is Judge Jackson sentencing so different? In possession cases, she gives 29.2 months. The average nationally is 68 months. In distribution of child pornography, her sentence is 71.9 months, and the minimum is 60 months. That's what you have to give. The average nationally, they tell me, is 135 months. The length of sentence for possession of child pornography imposed by Judge Jackson's is 57% less than the national average, and the area of distribution is 40% less than the national average. Why? Under the sentencing guidelines, a judge, if they choose, can enhance the sentence based on the fact that the perpetrator used the internet. Now, why do we want that as a sentencing enhancement? We want to deter the use of the internet when it comes to child pornography because there's already 85 million images and videos of children being abused, and that's the venue of choice. So instead of deterring that behavior, Judge Jackson routinely says that she will not hold that against the perpetrator. I think that's a mistake. She basically said it's so easy in a matter of minutes to push a button and download a bunch of files. That seems to me an unfair way to sentence somebody. She also takes off the table a sentence enhancement for the number or the volume of child pornography being possessed or distributed. I think that is absolutely backwards. I think what we should be doing is that every time you mash the button and download an image of a child being exploited, your time in jail should go up. That should be held against you. Accessing the internet should be deterred, not ignored. So what I have to say is that the National Center for Missing and Exploited Children released a report on the 2020 data. There's a 35% increase in child sex abuse material in a single year, 29.3 million reports last year of people accessing child pornography on the internet, at least 85 million images and files on the internet. And when it comes time to sentence these people, Judge Jackson will not impose additional punishment for the fact that the volume involved and the fact they're using the internet, the venue of choice. The more you download, the more you go to jail, is my view. I'm going to work with Senator Hawley to correct these practices. I think she's making a terrible mistake by not enhancing sentences based on the volume, because every click of a computer is destroying a life. And we should be deterring the use of the internet when it comes to child pornography. Judge Jackson chooses not to, and when it comes to the volume, that should be held against you. The more you abuse children, the more in your possession, the more you distribute, the longer you go to jail. And the reason her numbers are so low is because of that sentencing methodology. And I think if we don't fix this, we're making the problem worse. And I think her approach to this issue is absolutely wrong. It loses all deterrence. And I'll be watching like a hawk future nominees who are in the sentencing business to see if they follow this model. Because the model Judge Jackson has created is one where the more you do, it doesn't matter. The fact you use the internet where all the child pornography lies is not held against you, and I believe it should be. Every click, every download means you go to jail longer in the world that I want to create. The other area of concern, Guantanamo Bay. Remember this? This is 9/11. So Guantanamo Bay has been a place to house enemy combatants captured in the war on terror. Judge Jackson was a public defender, I think, for 4 or 5 Gitmo detainees, and that's a noble thing. I have no problem with somebody, a public defender anywhere in the country, defending very unpopular people, and people at Gitmo deserve representation. But what I found during this representation is that her briefs in the defense of Mika's briefs and Gitmo detainees accuse President Bush and his team of being war criminals. That's not defending somebody charged or held as an enemy combatant of being part of the enemy force. That's an accusation against your own government that I think buys into the language of the left. You can vigorously defend anyone captured as an enemy combatant or potentially charged with a crime against terrorism. That is a noble thing. But when you use the language that was in her brief, and she said, well, I really don't remember that, I have a hard time believing that you put your name on a brief that calls the President of the United States and his team war criminals. That is not about defending somebody. That is an activist approach to the war on terror. And it's further. In her legal briefs, she wanted to deny the United States the ability to hold Gitmo detainees under the law of war indefinitely. There's about 37 or 38 Gitmo detainees still held that have never been charged. We know through the intel and the evidence that they're hardened killers committed to the jihadist cause, and under the law of war, once their habeas petition has been reviewed by the federal courts, where the courts agree with the government that the person is in fact an enemy combatant, under the law of war, there's no requirement to release them, but Judge Jackson took the position as an advocate that we could not hold them indefinitely, creating a dilemma where you have to charge them with a crime or let them go. I don't consider these people criminals as much as warriors in a cause to destroy our way of life. If you choose to charge them with a crime, fine, but you don't have to make that choice. And the reason that there's 30 plus still in detention is we've chosen, Republicans and Democrats, to hold these people off the battlefield. If we'd accepted Judge Jackson's legal reasoning, that tool would not have been available to us as a nation, would have compromised our ability to defend ourselves. And I think that approach was the most extreme view of representation in this area, and I think it shows lack of understanding of the war in which we're in. We're not fighting criminals. These are not wayward goat herders. These are people committed to the jihadist cause and would kill us all if they could. The next area is immigration. And before I leave Gitmo, 31% of the people that have been detained since the beginning of the war have gone back to the fight. I will introduce that at the hearing next week. And that some of the senior leadership of the current Taliban government were Gitmo detainees that have now not only gone back to the fight, but actually have gone back to serve in the Taliban government that is raining oppression on the Taliban people. So to those who think this is a crime we're fighting, you're wrong. It is a war for the survival of good against evil. Immigration. In case you haven't noticed, this country is being invaded by illegal immigrants. Right after taking office, President Biden rolled back virtually every policy of President Trump regarding asylum, deportation, basically destroyed the regime created by President Trump that gave us the lowest number of illegal crossings in this country in 30 or 40 years at the end of 2020. Now, every week, we're setting new records. Why? The policies that existed during the Trump administration worked. They're being reversed by President Biden, and we're being overwhelmed, and the worst is yet to come. If the Biden administration, the CDC, does away with the ability to deport illegal immigrants under Title 42 of the Public Health Law, presenting a threat to COVID, then you will see the numbers go up even further, and there will be thousands, 18 to 20,000 people a day coming across our border from countries with low vaccination rates. So when it comes to illegal immigration, policy matters. When Judge Jackson was a district court judge, there was a case brought by Make the Road New York et al. Versus McAleen, who was the acting DHS secretary under President Trump. The group, Make the Road New York, was an Arbella activist group. This is a kind of a holding company, for lack of a better word, an umbrella group funded by George Soros and a bunch of other liberal billionaires. This group in that chain, receiving money from these folks, filed a lawsuit arguing that the Trump decision to deport under expedited immigration authority people who've been here 2 years or less, to change Obama policy and actually fully implement the authority given to the DHS secretary. They decided to go to full 2 years. Anybody here 2 years and under in the category in question could be deported with expedited procedure, meaning it was a quick turnaround. This was the authority given by the Congress to the DHS director. Obama didn't use that authority fully. Trump decided to do it. Make the Road New York et al., a bunch of liberal groups, sued the Trump policy change. Judge Jackson was the judge, and she overruled the Trump decision, and the statute in question said that the secretary has the sole and unreviewable discretion to use expedited deportation for people 2 years or less. This statute could not have been written any clearer. And if you're looking for what an activist judge is all about, this is the case, Exhibit A. The law was written in the most clear terms, saying the decision of the secretary is unreviewable and solely in their hands when it comes to using expedited removal procedures for people here 2 years or less. She ruled against the Trump administration, and she basically said this was arbitrary and capricious. It reeks of bad faith, showed contempt for the authority that the Constitution's framers have vested in the judicial branch. That contempt she's talking about was a congressional act. The congressional act was designed to tell judges that the DHS secretary has discretion in this area, solely and unreviewable. She found that concept offensive. So instead of following the plain letter of the law, she did legal gymnastics to find against the Trump administration. And when she said the statute created contempt for the authority that the Constitution's framers have vested in the judicial branch, what she's saying, I'll be damned if I'm going to be limited by a congressional act that tells me I can't do what I want to do. And the plaintiff in that case was from the radical left, and she ruled for them in spite of the plain meaning of the statute, and she was overturned by the D.C. Circuit Court. The court said, and this is a fairly liberal court, there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within statutory bounds to the Secretary's independent judgment. The forceful phrase, sole and unreviewable discretion, by its exceptional terms, heralds Congress's judgment to commit the decision exclusively to agency discretion. She ignored the plain meaning of the statute, the language of the statute, to get a result she wanted, and the D.C. District Court of Appeals said that there could hardly be a more definitive expression of congressional intent. That is judicial activism on steroids, and it makes managing our immigration problem even worse when you have activist judges that ignore the law, take discretion away given by Congress to the executive branch because they don't like the outcome. That is, in fact, the premier definition of judicial activism. And I find in her judging a desire to get an outcome, and no matter what she has to do to get that outcome, she will pursue it. And this is a case where you couldn't have written a statute more clear, and she just went around it, got the result she wanted, and slapped down on appeal. Now, she is the first African-American female slotted to go to the Supreme Court. She, however, is not the first African-American female that had potential to be on the Supreme Court. Janice Rogers Brown was nominated by President Bush 43 to be on the D.C. Circuit Court of Appeals, one of the premier appellate courts, like Judge Jackson was nominated to. She is from Alabama. She was the daughter and granddaughter of sharecroppers growing up in Alabama during the Jim Crow era. She moved to California as a teenager, and she wound up serving on the California Supreme Court. She was a single mother raising children. In June 2005, she was confirmed to the D.C. court in a 56-43 vote. That was after the Gang of 14 broke a filibuster by my Democratic colleagues against her and others. She was nominated in 2003, and her nomination was stalled for 2 years. Here's what Senator Schumer said. Judge Brown was the least worthy pick this president has made for the appellate court. That's based on a record. Senator Durbin in 2005, one of the president's most ideological and extreme judicial nominees. 2005, if the president sends us a nominee who, like Janice Rogers Brown, believes that the New Deal was the triumph of socialist revolution, there will be a fight. Here's what Senator Biden, then Senator Biden, said about Janice Rogers Brown. Not only did he filibuster her, he said, I can assure you that they would be a very, very difficult fight, and she probably would be filibustered if she were nominated to the Supreme Court. So, to my Democratic colleagues, As you celebrate Judge Jackson's potential ascension to the court, as those of us on the committee who asked penetrating, relevant questions of Judge Jackson's judicial philosophy, how she sentenced people and why, the liberal media that's completely in the tank on issues like this, sat on the sidelines and watched you, my Democratic colleagues, stop the ascension of an African-American conservative nominee by President Bush. And when it came to her potential of being on the Supreme Court, you threatened to filibuster her. You considered her ideology unacceptable and too conservative. So if you're a conservative nominee of color, a woman, it's okay to use your ideology against you. If you question the ideology and the judging ability of a liberal African-American nominee, you're a racist. Those days are over for me. So I have very little respect for what's going on in modern America when it comes to judging. Miguel Estrada was nominated by President Bush 43, a highly qualified man, Hispanic, to be on the court, and he fell victim to the filibuster, the wholesale filibuster of Bush nominees in the 2003 era. He didn't make it through the Gang of Eight. Judge Janice Brown got on the court, 2 years delayed, and when she was being considered to go on the court, Senator Joe Biden said she will be filibustered, very, very likely. So we live in a world where if you're a person of color, a woman, and you're a conservative, everything is fair game. If you're a person of color and liberal, how dare anybody question or use the same standard against you that was used against the other nominees? I don't accept that. And finally, about the hearing itself. To the liberal media, comparing this hearing to Judge Kavanaugh is an absolute offense. Nobody on the Republican side held information back accusing Justice Brown of doing something that was either made up, not credible. Nobody questioned her high school annual. Nobody took a bunch of garbage and made it seem like that the nominee had been Bill Cosby in his teenage years. Crazy stuff, offensive stuff. What we did ask Judge Jackson is, why do you sentence the people the way you do? Explain the reasoning in the cases involving child pornography. And we went after her judicial philosophy, and it had to be contentious because the judge seldom would answer a question. But to me, if you're going to be nominated to the Supreme Court for a lifetime appointment, you should expect to be asked hard questions. You should not expect to have your life destroyed. And if you don't see a difference between the two hearings, then you're blinded by your desire to get an outcome. Here's where we're at in 2022. The only person qualified to go to the Supreme Court as an African-American woman is a liberal. You can be equally qualified as a conservative, but you need not apply because your ideology disqualifies you. That's not exactly the advancement I was hoping we would have in America in 2022. So Judge Jackson, I will vote no. I find her sentencing methodology to reinforce and take deterrence of the most heinous offenses off the table. The statements she made during the sentencing hearings showed a tilted sense of compassion. I'm sure she doesn't like the behavior and feels sorry for the kids, but every time she had a chance to increase punishment for the volume of material in the hands of the perpetrator, she chose not to do that, and I think she should. And going to the internet to her and downloading a bunch of files is too easy to enhance punishment. well, it's just too easy to destroy lives. So when it comes to immigration, it's the most egregious case I've ever seen, quite frankly, of a judge ignoring the plain meaning of the law to get a result they wanted. And when it comes to the war on terror, I think the position she wanted our country to take would make us less safe. And the language of the left in her briefs of calling Bush a war criminal says more about the politics than it does the merit of the argument. So now I know why Judge Jackson was the preferred pick of the radical left. Now I know why they went after Michelle Childs, somebody I could have supported, even though she had been liberal, highly qualified, sensible, common sense person. Now I know. Now I understand better. And that's why I'm voting no. To my Democratic colleagues, I'll work with you when I can, but this is a bridge too far. Thank you.